can't stop by voting for the resolution.
Thank you.
Good morning, ladies and gentlemen, distinguished guests, speakers, and colleagues. It is my great pleasure to welcome you to the Singapore Arbitration Dialogue. My name is Karen Tan, and I'm the Chief Strategy Officer at Maxwell Chambers. This dialogue was created to provide a forum where leading voices in Asia can come together for substantive and meaningful exchange, and also add a little bit of humor as well. Asia's role in international arbitration has never been more significant. The 2025 Queen Mary survey shows that users now look to Asia as one of the leading arbitral seats. This reflects the region's broader economic significance. According to the International Monetary Fund, Asia accounted for nearly 60% of global growth in 2024. More trade and investment flowing through Asia inevitably means more disputes, and with them, greater demand for credible and effective dispute resolution. It falls to us, therefore, to ensure that arbitration in this region continues to adapt to meet the needs of the international business community. Singapore is proud to play its part in this journey, and we at Maxwell Chambers are committed to supporting this ecosystem and to also invest in our future. Next year, during Singapore Convention Week, we will launch the Maxwell Challenge, a premier mediation competition designed to mirror realities of practice and the entire mediation process, from client consultations and negotiations through to mediation and crafting solution outcomes that last. Today's dialogue also contributes to that future. It is part of a growing library of exchanges that helps us reflect on the past, engage with present challenges, and shape the future of arbitration. We are honored today to be joined by Justice Philip Jeyaretnam, President of the Singapore International Commercial Court, and the Honourable Geoffrey Ma, former Chief Justice of the Hong Kong Court of Final Appeal. Together, they bring decades of judicial, institutional, and practitioner's perspective. And with such esteemed guests, we could not have asked for a better moderator than Sheila Ahuja, a highly regarded arbitration practitioner with extensive experience in international arbitration across this region and beyond, which makes her the ideal person to steer today's conversation. So no pressure, Sheila. I had prepared much more to say about each of them, but in the interest of time, and because they truly need no introduction, I shall not delay us any further. So without further ado, it is my privilege to invite the distinguished speakers to begin the dialogue. Thank you.
Thank you very much, Karen. Good morning to all of you. And what a pleasure it is for me to be sitting here on the Monday morning of Singapore Convention Week this year. Thank you all for coming. I'm going to start with 2 points of introduction. The first is a formal thank you to Maxwell Chambers, Karen in particular, for organizing the second edition of the Singapore Arbitration Dialogue, for thinking of me to moderate the event, and pressure very much taken, Karen, for having such a fantastic audience present, which I'm really pleased to see, some familiar faces, such well-respected ones as well. And most importantly, for securing the esteemed and magnificent guests that sit here next to me today. Second, by way of format, what I propose to do is kick off with a short or not so short introduction to each of our guests, not because they need it, but because if I look and sound nervous right now at the prospect of interviewing them, then when I share with you the details of their achievements, you'll understand why. Once I've done that, I will then have the pleasure of directing questions at either, or sometimes both, sometimes with notice, sometimes without, questions about a dialogue in arbitration, which I've broken down into a couple of themes, if you like. And as the event suggests, it's meant to be a dialogue between us. We'll explore certain topics from the perspectives of arbitration and also from the angle of the judiciary, of course. I'm also aware that there's an opportunity, time permitting, for the audience to ask questions. So we'll see how we go. And of course, I have my own burning questions and I have the microphone, so I'm afraid I get to go first. With that, I'm going to first introduce the Honourable Geoffrey Matali, GBM KC SC. That is longer than I've had to type for a guest name in a very long time. In 1978, Justice Ma was called to the bar by Gray's Inn in London and commenced his practice as a barrister in England and Wales. He was then called to the bar in Hong Kong, State of Victoria, Australia, and Singapore between 1980 and 1990. His counsel career comprised over 2 decades of a thriving commercial, constitutional, and arbitration practice in Hong Kong and Singapore, which included in significant part his appointment as Queen's Counsel in 1993 and his role as head of Temple Chambers, of course, as we all know, in Hong Kong. He also held and fulfilled a number of public positions alongside his thriving practice. And all of this is just the start of Justice Ma's achievements. In 2000, he was then appointed by the Hong Kong judiciary as recorder of the Court of First Instance of the High Court. And the very next year, he became a judge of the CFI. Only a year later, he was then elevated to the position of Justice of Appeal to the Court of Appeal of the High Court. And again, within only a year, nobody waited very long, to put Justice Ma into the position of Chief Judge of the High Court. In 2010, Justice Ma was voted as Chief Justice of the Court of Final Appeal, a position he continued to hold until 2021 when he stepped down. Relevantly, during his judicial tenure, relevantly to today, Justice Ma was also a member of the Working Party on Civil Justice Reforms, which came into effect back in April 2009 and were aimed at lowering legal costs and improving access to justice. This is one of the themes we'll pick up today. Unsurprisingly, Justice Ma has received numerous recognitions of his achievements, including notably the Grand Bohemia Medal, reflecting his lifelong commitment to Hong Kong's well-being. Since retiring from his judicial role, Justice Ma has returned to private practice as an arbitrator and mediator at Temple Chambers in Hong Kong and Brick Court Chambers in London. He's also been appointed as honorary professor of both the University of Hong Kong and the Chinese University of Hong Kong's respective law faculties. That's just the short version of the introduction that I managed to put together. I could spend the rest of the 45 minutes continuing to roll out Justice Ma's accolades, but what I will do is move on to yet another esteemed guest, the Honourable Philip Anthony Jeyaretnam, SC BBM Judge of the High Court of Singapore. After reading law at Cambridge and graduating with first-class honours in 1986, Justice Jeyaretnam was called to the English Bar in 1987 and the Singapore Bar the following year. Following a more than promising start in private practice, he was conferred the title of Senior Counsel in 2003 when he was only 38. At that stage, I was only just figuring out what to do with my own career, so this was a real data point for me. Justice Jeyaretnam was appointed managing partner of Roddick and Davidson in 2011, and then later, having led the firm's combination with Denton's in 2016, he became CEO and global vice chair of Denton's, Roddick and Davidson. He served as president of the Law Society of Singapore and was founding chairman of the Society of Construction Law from 2002 to 2004. He was adjunct professor with the Department of Building at the National University of Singapore from 2005 to 2013. He served as chairman of Maxwell Chambers here from 2010 to 2020, for which he received the Public Service Star in 2021. Around the same time, he also received the C.C. Tan Award from the Law Society of Singapore, which is an award given to those who best exemplify the bar's traditions of integrity, fairness, and gentlemanly conduct. In 2021, Justice Jeyaretnam was appointed as a Judicial Commissioner of the Supreme Court of Singapore. He was appointed as a judge in November 2021 and is currently, as Karen said, President of the SICC. He's also concurrently a member of the Judicial Service Commission and the Presidential Council for Minority Rights. And in addition to all of this, Justice Jeyaretnam is also an author. His writings have found him receiving many a prize, including in 2015 when one of his novels, Abraham's Promise, was selected by the Business Times as one of the top 10 English Singapore books from 1965 to 2015. Now, I'm sure with all of this, you in the audience will believe me when I tell you that this is a nerve-wracking position to be sitting in against that background, and that I could sit down and tell you about each one of those steps in more detail. But instead, what I'll do is stop there, and hopefully with what was somewhat of an accurate flashback, you'll correct me if it wasn't, to ask each of you my first question, which is to share with this audience some of the more defining moments of your professional journeys and how you'd say you got to where you are today. Geoffrey, if I can start with you.
With that sort of glorious introduction, most of those accolades were paid for, by the way, and not really well deserved. I don't want to add too much. I would just like to add 2 points, both to do with arbitration. The first is this, that since I practiced in arbitration when I was in practice, took a 20-year break from that practice when I joined the Hong Kong judiciary. A lot of changes have taken place, not least of all during that time. During my time in practice, the go-to place for big commercial disputes was still the courts. Now, of course, the go-to forum for heavy commercial and wealthy disputes would be arbitration. That's the first point, which I've noticed. It's not really in my career, but I'd like to mention. The second point is a more important one on my CV, and it's this, that I dare say not many people in this room would have had the chance in the course of his or her legal practice to have cross-examined Michael Huang. I'm one of them. I can say, and he's looking at me because he was, he's smiling. I'm glad you did. Well, to no avail, by the way. I did my best, but could not break Michael Huang. But at least that is a feather in my cap. So that's the only 2 additions I'd like to make.
Thank you. Very, very nice additions. And the first point I'll come back to actually ties in with one of our themes. But Philip, if I can ask you the same question.
Sure. I need a mic. So,
Are you sitting on it?
I think you might have it.
oh, yeah, I'm sitting on it. Well, that's yeah. I think that's what I tend to be doing most of the time these days, sitting on things. Yeah. But let me just offer a couple of well, stories from my own journey, as they say, which hopefully, perhaps particularly to visitors to Singapore, may also illustrate some of the journey that Singapore has been on. And the first is from one of the first cases that I actually did as an arbitration counsel. And this is back in the late 90s, when Singapore was just beginning to see arbitration matters, other than sort of basic building cases. And in that case, I was very glad to win completely initially, because we won on the counterclaim. We dismissed the counterclaim, won on the claim. After that, the arbitrator, however, had second thoughts and decided to change on application by the respondent his decision on the counterclaim. So naturally, we then applied to court to set aside that additional award on the counterclaim. We were still in the black because the claim that we'd won on was intact, and that was much larger than the counterclaim. At first instance, we won before the judge, who was an experienced shipping lawyer in practice, and so was very familiar with arbitration. On appeal, unfortunately, or fortunately for the other side, we lost on that, and the Court of Appeal held at that point that until the arbitrator has decided all issues in the arbitration, including costs, the arbitrator can go backwards and change earlier decisions. So that obviously was wrong, and that was in the early days of Singapore as an arbitration seat. And the thing which I'm going to come to, which is a hallmark of Singapore, is that was very quickly corrected. And you will see a number of provisions in the International Arbitration Act and also consequentially in the Arbitration Act about the finality of awards, which you don't really see elsewhere. And it's because that, I suppose, fairly clear principle to an arbitration lawyer hadn't been picked up, and therefore it needed to be expressly put in order to correct that earlier decision. So that's part of Singapore's journey, the way we have moved from being new to arbitration to being a sophisticated seat, and along the way, lots of hiccups, but a direction to all of that. And the second, if I may mention, is in something I'm very, very proud of, is and really enjoyed and was very honored by, was my stint as chairman of Maxwell Chambers. And what I wanted to mention there was, again, to kind of illustrate the way in which we work, because Maxwell Chambers, as you may or may not know, is owned ultimately by the government via Ministry of Law holding company, but the board is a private board, and there's a sort of public-private partnership for the development and growth of Maxwell Chambers. And the specific thing I wanted to mention is, if you look at that building next door, that very nice building, which is now connected with an aero bridge and is part of Maxwell Chambers, when I became chairman, it was really a bit of a dump. It was used for design. There was a small design museum, and then there were lots of like tailors and people like that. It was meant to be a sort of design center. When I walked around it after becoming chairman, I thought, this place, what does it remind me of? Well, it reminds me of the Inns of Court with these little, staircases. Of course, it's been after renovation. It's a lot nicer than the Inns of Court. But at that point, it was reminded me of pupillage and walking up and down rickety stairs, where you might get stuck if you were carrying too many books and so forth. And I then put the proposition to the Ministry of Law that we could perhaps reconfigure it as part of a legal precinct, and it should be, it's much more fitting in this part of Singapore to have legal institutions. And so in addition to this building, we then moved on to the next project of refurbishing that building next door, which is now Maxwell Chambers Suites. And so I thought I'd use that as an illustration of my own journey as well as of Singapore's journey.
Thank you, Philip. That's a very interesting point. And actually, I'll come back to the growth of Singapore and Asia as one of the themes as well. I feel like you've read my script, even though I'm sure I didn't share it. I will move on then to the first substantive topic, if I may. And actually, it's picking up a little bit on, Geoffrey, your first comment around the courts having been the go-to forum historically. I think it's probably fair to say, and I'm sure the room would agree, that arbitration has gone through a process of evolution from being the subject of close scrutiny of the courts historically, as Geoffrey said, and I'm sure most of us have seen this if you were around long enough, like some of us, that the courts have definitely seen an evolution in their role of how much they supervise an arbitration. Where the presumption now, and consciously, is that the courts will not interfere. It's seen as interference, and the rule is do not interfere, other than where expressly provided or where appropriate or effective. To illustrate this, I want to draw on just a couple of points of reference, just to highlight the nuances of this. At the CX Symposium last year, Justice Judith Prakash, who actually I found out from Karen was the guest speaker at last year, so the first Singapore Arbitration Dialogue. I was lucky enough to have all these esteemed guests sitting here on this stage. Justice Judith Prakash described the relationship between courts and arbitration as a partnership. What she said is that courts are not competitors with arbitration, but rather vital partners. And as she put it, no system of dispute resolution can exist in a vacuum. This partnership is about each doing its best in the service of justice, rather than working at cross purposes. Obviously, if I could do that in my marriage at home, then things would be a lot better. But the idea is, I think, right. Similarly, in the 2024 Kaplan lecture, you, Geoffrey, observed that while arbitration is fundamentally different from court litigation, parties do not sign up for a lesser standard of justice when they choose arbitration. You stress that the arbitral tribunal bears the responsibility to get it right the first and only time. And this goes to Philip's point of finality as well, since the courts do not interfere with the merits of arbitral decisions. And of course, looking at statistics, and Karen mentioned Queen Mary, the surveys year on year consistently show that the most attractive arbitral seats are actually those where the local courts are seen as supportive, neutral, and actually helping enforce and not disturb the arbitral awards. So against that proposition of this shift of courts not interfering, letting arbitrators get on with it, and not being the go-to default, to what extent should today's arbitrator, and this is a question for you, Geoffrey, to what extent should today's arbitrator, when performing their mandate, be mindful of how a court would view their decision?
Right. It's an important question, and in it has various nuances. You've already described the symbiotic relationship between the courts and arbitration. I don't want to go into that, but the one of the manifestations of the hands-off approach of the courts over the years, and this is confirmed by legislation in most jurisdictions, is that it is tempting for a lot of arbitrators or those in arbitration to think that hands-off means that looking at what the court does is irrelevant. And a lot of arbitration practitioners I've spoken to think, well, arbitration is one thing, the courts are another, and really are quite proud of the fact that we are developing our own style, our own procedures, our own way of doing things, that looking at what the court does is quite irrelevant. Now, having introduced that, then you add on to this. You mentioned already the one-stop shopping, is what I like to call it, of arbitrations. There's no right of appeal. So the buck stops with the arbitrator. I've mentioned a little earlier the fact that big money claims, commercial claims, now go to arbitration rather than the courts. All these two factors alone pile on the pressure for arbitrators. Now, many arbitrators won't tell you this, but it is a very real pressure, because the pressure is you're very much on your own. It is a one-stop, so that the parties, all parties, expect you to do the right thing and to do it well. I mean, you mentioned something which I've said earlier in an earlier speech. I've said it in a number of times, that you have one chance to get it right, and it's the only chance. And that really does apply a pressure point. Now, the point I'm getting to is that arbitrators can need all the help that they can possibly get. And part of this comes from observing court procedures. And I'm talking about the management, not so much really the outcome. The merits part is just application of law to facts, to put it in a simple way, which is not easy, but you know what to do. It is the management of an arbitration, the procedural part, which is now becoming ever increasing and ever more complicated. And indeed, in an arbitration, it takes up most of the time and probably a lot of the expense, probably most of the expense in an arbitration as well. So on that, what sort of guidance can you get, can arbitrators get? And I think you look at the courts. Now, I was in charge of implementing the civil justice reform in Hong Kong, as well as part of the committee which drafted the amendments. What comes out of it are the underlying objectives which have been put in statute form. The underlying objectives are similar to in Singapore what are called, I think, the ideals of whatever name you call it, it boils down to this: the need for an expeditious resolution to the dispute. And in the expeditious management of a case, you've got to look at proportionality. A claim which is worth $30,000 may, in legal terms, be as complicated or as simple as a 300 million or $3 billion claim, but the management of it is quite different, because in the massive claim, you can manage it accordingly. In a smaller claim, you can't give what some people have called the Rolls-Royce treatment, because at the end of the day, the claim may be 30,000, but the legal costs are enormous. We all know actually how costly arbitration can be. And therefore, you've got to have an eye towards proportionality. But above all, as Judith Prakash said, you're looking at the fairness or the justice of the situation. That's an easy phrase to use, but to apply it when you're talking about procedural decisions is not always easy, because what is fair to one party may be regarded as unfair to the other. It could be as simple as asking for extra time to put in your pleadings, your statement of claim or your statement of reply, or to comply with discovery applications. One side says, well, actually, we're on a holiday season. Our people are not around. The clients are not around. I think we need an extra 28 days. This is pretty usual in an arbitration. It's usual in court, by the way. So the other side says, well, that's ridiculous. You've agreed to this procedural timetable months ago, if not a year ago, and now suddenly you know that there's a holiday and you say 28 days. I say 0. It's unfair of you to ask otherwise. The 28-day requester then says, I really needed 28 days. So immediately, on something as simple as an extension of time, the arbitrator is faced with opposing aspects of fairness. And what guides you? What guides you, of course, is your own instinct, but your instinct is based on what is required in terms of expediency, proportionality, and generally taking into account what is fair. And here, arbitrators can look to what courts do, because courts do this all the time. And I mentioned the underlying objectives, the ideals, because courts are faced with this every day. So some guidance can be obtained by looking at what the court does, as opposed to simply dismissing what the court does as quite irrelevant to an arbitration. Sorry, that's a long way of answering the question,
but most useful. And actually, I'm going to pick up on a point you made there about the starting point, Geoffrey, of your answer was that sometimes the view is that courts are irrelevant, and actually arbitration should be just a self-standing process. And to what extent should court procedures be observed to benefit the arbitral process to run more efficiently? I started my career as a litigator in Hong Kong, and I remember that the first victory I ever had, and I remember it because there were so few in my career, there have been, hopefully there'll be more going forward, it was an unless order. And it was, you know, if you miss the first deadline to file something, you only get one more shot, and then that's it, you get summary judgment. So it was actually a default judgment rather, and it was actually one of the most interesting aspects that when then I flipped over to arbitration, the default has been that you expect a time extension. Obviously, we as a firm do not operate on this basis, just to be very clear, but you know, it is the reality of arbitration that you get into this mode of there's a timetable, but the hearing dates are sufficiently far away that leeway is assumed. So Philip, with that, I'm going to flip the question round, given your current function, and say, should the courts then, when discharging a supervisory court function, so when you're sitting as a supervisory court judge in an arbitration seated here, be guided by the autonomous nature of arbitration? Or should you say, no, I'm far from irrelevant, I'm going to guide the procedure here for you?
Okay, well, the short answer to your question is no, the court is not going to guide the procedure for arbitrators directly. And there is a broad measure, when it comes to looking at procedural decisions, such as the one that Geoffrey had talked about, 28 days versus 0, the broad test is that the arbitrator's decision, as long as it is within the range of what a reasonable arbitrator might have found, or any reasonable arbitrator might have decided, is not going to be disturbed by the court. But I think that I'd just like to make a couple of points to your question. The first is I think it's important to get the analogy or the metaphor right for the relationship between the courts and arbitrators. Unfortunately, I disagree with Justice Prakash that the right metaphor would be, I'm not sure it was necessarily putting it forward, how she was putting it forward, but it is a partnership. It's not a partnership, right? The courts play the indispensable anchoring role for arbitrations. You cannot get your arbitration award enforced unless you go to court. So everything ultimately goes through a court. The arbitrators only build on the power of states to enforce awards within the scope of autonomy. But that certainly doesn't mean that courts are going to be quick to interfere with arbitration awards. All of the ways in which there's going to be intervention, and it's not interference. The ways in which there would be intervention are ones which are set out very clearly in the model law and in statute, and it is the court's legal obligation to apply those tests to arbitration. So then the next point is, well, when it comes to arbitrations, I don't know whether any of you remember the old slogan of the police force here, when they were trying to combat complacency among the public who thought it was just okay to leave their iPads lying around and stuff like that. And the slogan was, low crime doesn't mean no crime, which was an important corrective for Singaporeans because we were kind of beginning to assume that just because we have very low crime rates, you can pretty much behave as you want without any risk of criminal activity. And the same concept applies. There is low levels of interference, to use Sheila's term, or low levels of intervention, but that doesn't mean that there should be or would be no intervention, because if there is, if an arbitrator goes beyond their jurisdiction, if an arbitrator is in breach of natural justice, there not only that can there be, but there must be intervention, and so that will happen. And so, just to quickly go on to the third point, hopefully, it's really important, of course, in anything we do, to have a sense of accountability. And so if arbitrators think that because they have so much, or if an arbitrator thinks that because they have so much leeway and so much discretion, that they are not accountable, that would be a serious mistake in the way you're approaching your own cases. You need to have that sense of accountability. Whether you get that from an accountability to the concept of justice, some of us would draw on that. It might be you have a sense of accountability to the parties, but got to make sure it's to both parties, not just to one party. That's a serious error in itself, to feel accountable only to one party. But to the extent that the courts are there in the background and there is some accountability, that's also very important. And it then sets up the frame for properly directed, properly self-directed decision-making on the part of arbitrators.
Can I just very quickly sort of just putting on my well, actually, I was say judicial cap, my ex-judicial cap in relation to this, the way that courts have looked at when looking at arbitrations and what arbitrators do is this: that there is a very distinct limit to how much a court can, as it were, interfere with what an arbitrator does. And you've highlighted it very well, Philip, and I agree with that. But it can interfere in very important ways, such as really important ways, such as denying enforceability and so on. And it will look at what has gone on in an arbitration with a keen eye. If the arbitrator has been, hopefully so never, but sometimes happens, cavalier in the approach, been unfair, been really acting out of turn, this will be reflected in the way that the court looks at it. Because when you put it, of course, there's been a denial of natural justice. That is actually quite a broad concept. It covers a lot of things, and it certainly covers a situation when the court believes that something bad has gone wrong. So it is this element of accountability I fully agree with.
Actually, Geoffrey, if I can keep to you on this point, does it create a situation of a conflict of interest for the arbitrator? If you think about it from the perspective of accountability and, you know, with the supervisory court sort of hovering above it, if you like, on the one hand, and on the other hand, of course, in contrast to the elevation of a judge, an arbitrator is appointed by the very people that it gives its decision to. The award comes, well, hopefully only 6 or 9 months later, but sometimes 2 or 3 years later. And what happens in the tenure of those 2 or 3 years of an arbitral process is constant situations where an arbitrator is put on the spot or asked to make a decision, whether to do with a time extension or some kind of procedural remedy. And the arbitrator is mindful, of course, that the next appointment may well come from that room, or, you know, communities are small, some other related or connected room. Is there an underlying conflict in that situation? And does it impede the ability of the arbitrator to really fully discharge that function in the way that a judge can do?
Well, questions built into that. First is, you mentioned the concept of the court hovering above the arbitrator. That's not how it should be looked at, nor how arbitrators should see it, and certainly not the way the courts see it, that there is some sort of, I am hovering, so you better watch it because I've got my eyes on you. You see, I don't know how many Hollywood films you see where the good guy does that, sort of, which I really dislike. But yeah, it is not. It's not like that at all, because to this extent, Judith is right that it's a sort of partnership. You are looking to achieve the same end here. And what is fair and just in the circumstances. Now, the second part of your question deals with conflicts. And this is something which has always bothered me, because in a litigation, whether arbitration or the courts, involving legally represented parties, there are inherent conflicts here, which everybody recognizes. For example, the conflicts reflect the different relationships in a litigation. First, of course, the relationship between counsel and the courts or the tribunal. The second is the relationship between the lawyers and their own clients. The relationship between lawyers on the one side and the lawyers on the other side. The relationship between the lawyer and his or her own firm and the firm's interests. All these give rise to conflicts which can pull in any given case in different directions. I don't think I need to elaborate on that. When you get into arbitration, there is an additional conflict here. And this arises from the fact that an arbitrator is paid. An arbitrator is appointed by the parties, let's say on a 3-person arbitration, one by each side, then the person in the middle, and everybody is paid. So there's a commercial, if you like, interest in this. And that can subconsciously give rise to a conflict, particularly when, if you talk about Asia, and I think in Europe as well, and they must do, the arbitration circle is relatively small. And anybody who's sat as an arbitrator will realize that you get asked by firms to act as an arbitrator on a repeated occasion. Now, that's the reality. Now, this should not cause you to do your job any differently on each occasion, but subconsciously it does, because I've certainly heard anecdotally that as far as, let's say, more junior arbitrators are concerned, people starting out, there is a temptation to want to get more and more appointments from the right people, from the established firms, and that can cause a conflict. Sometimes it's self-generated, sometimes not, because I go back to the fact that commercial arbitration involves a lot of money, and when a lot of money is involved, there are a lot of tactics in this. Sometimes you can't help but feel that there may be, hopefully not on many occasions, in my case, I hope not on any occasion, where people are seeking indulgences from the arbitral tribunal on the basis that, oh, I know you, I've appointed you many times, and so on. So I can sort of take advantage of the fact that you sort of trust me. Now, that accounts, by the way, for why before you take up an arbitral appointment, you have to make declarations of interest. But very often declarations of interests are made. But at the back of it, there is slight niggling feeling. And it is this conflict of interest, which I think hopefully is not real, but I suspect in some cases may be real. It's something which an arbitrator needs to bear in mind. The answer to that is, of course, quite simple. You do your job, irrespective of who's appointed you. You do your job, right down the middle. And if it causes offense or whatever to somebody or other, it's just too bad. Because at the end of the day, and this is something which arbitrators should bear in mind, and those who practice arbitration should bear in mind, that arbitration, like litigation, is not a game. It is not it's not a game of chess. It is a serious legal contest which deserves to be decided along the right lines, and that is the Judith Prakash line of what is fair and what is just.
Thank you, Geoffrey. And I think the conflict of interest point is one angle for sure, which I think you've covered extremely well. The point you made about how then to perform your duty and try and do it down the line, stay straight down the line. Of course, it creates a different type of conflict, not a conflict in terms of appointment, but a conflict in terms of how to balance situations where one party is clearly playing by the books and the other party is quite objectively recalcitrant. And that measured against what is an obvious ground and is a ground across many jurisdictions of challenging an award. As we all know, can't really do that on its merit, or you're not meant to. But the most obvious one is where a party hasn't had a fair opportunity or a reasonable opportunity or sometimes a full opportunity to present their case. And that leads to the very well-known term due process paranoia. And I'm not going to keep citing the Queen Mary statistics, but I did go back and look at them, and year on year, users are increasingly saying, and it went from comments to there should be more active case management, to more recently where there's a specific call for cost sanctions being asked for delay, and for rules for arbitrators to have more extensive and more active case management. The most recent survey reinforces this and basically says that the lack of proactive case management is one of the top factors that negatively impacts arbitration efficiency. Now, against all of that, so just on the topic of due process and this idea of the paranoia of due process. Philip, if I can ask you, what should a court do then when assessing an arbitrator's conduct and then having to balance, how would you assess the situation of having to balance this idea that arbitration is increasingly autonomous and one ought not to hover over the process, but at the same time, when there is an obvious issue with what's happened in terms of procedural fairness and efficiency?
Well, just to go back to the test that we apply in Singapore, it is one that should not generate this due process paranoia, because as I indicated earlier, the question that is asked, the test is this within or without the range of what a reasonable arbitrator might have decided in those circumstances, as known to the arbitrator at that time in that room, with all the indications of that counsel was giving off at that time. So that's a very it gives the arbitrator a very broad discretion. And I think that shows up certainly in the statistics. If you seat your arbitration in Singapore, then the number of times that an arbitration award will be overturned for natural justice is probably around 1%. Because it's probably isn't any more than that. It might even be significantly less than that. So it's quite difficult and rare to have natural justice challenges succeed. But in a way, what we do see as a separate phenomenon is the number of times that merits challenges are shoehorned into natural justice challenges. And you can see that one party is quite obviously unhappy, and actually as a judge it's often very obvious that they are justifiably unhappy with the way in which the law or the facts have been approached. And so you have that other group. I mean, if you look at it from a system-wide point of view, arbitration now has built into it a situation where quite a large, well, there's no way to know what the percentage is, but a number of cases where the arbitrator is probably going wrong, and I'm not saying it's for any nefarious reasons, but there's no way to correct it. And so that creates an issue for arbitration as a system, which institutions might well want to think about, because it may undermine the attractiveness of arbitration to the business community.
I'm going to take this point that you just made about should there be a way to correct unfairness that comes out in an award.
This is errors rather than unfairness.
Or it could be both, you think, or you're focused on actual errors that you can't correct in terms of merits.
I mean, that was my point, that errors of law or fact get kind of pushed into a challenge on natural justice because that's the only way you can challenge it in court. So you then say, well, there's an error of law, but this error of law came about because the arbitrator didn't listen to me properly, right? And there's all sorts of things, didn't provide a reason, all sorts of things which they put into natural justice.
Yeah, and that's interesting because, of course, sometimes, as you rightly say, the error is disguised as a procedural or trying to fit it into, I guess, one of the grounds of how you might well be able to challenge an award. But I'm going to take it in two steps. The first is where this often comes about, and in terms of a party and their client and choosing the forum, is emergency relief or the injunction judge. So, and then I'll come on to the award itself, but looking at the start of the process, those are potentially the two substantive points, the emergency or interim point, and then the final award. So dealing first with the interim stage, and many in arbitration begin because there is need for emergency relief, because there are legislative provisions and arbitral rules that enable you to go to an emergency arbitrator. And what started off as a great option to the injunction judge has now seen itself heading towards being a default. So the default is now that if you choose the the right to go to an EA in your rules or by way of your arbitration agreement, that is what you should do first, unless it's better to go to a court, and the test may vary depending on jurisdictions. So my question, maybe sticking with you, Philip, first, if you don't mind, is speaking from your perspective and over the years of seeing EAs develop, is one more effective than the other? Is it actually a good forum to have the default of an emergency arbitrator?
I think probably the best starting point to answer your question is, again, just to go back to what the position is in law and how we interpret that in Singapore. So under our International Arbitration Act, we certainly do have power to support an arbitration through granting an injunction. But there are conditions for the exercise of that power. And the first condition is that the arbitral tribunal is not able to act effectively. So really that, and then the second is urgency. So with both of those conditions in place, that presents a hurdle. So first of all, certainly your arbitral tribunal probably can't have been constituted. It's quite difficult to say, unless you can really show urgency, that you can come to court once the arbitral tribunal has been constituted. The second thing, even with an emergency arbitrator, I mean, the cases that we have had, and I've had a number of cases, including recently, cases that we have had where we would grant an injunction would really be where it's because the emergency arbitrator is unable to act effectively because of the notice requirement that an emergency arbitrator is under. So effectively, if you go to the emergency arbitrator, the other side will know in advance of the order that the application has been made. And so the argument can be made to the court, and is sometimes accepted and sometimes not, that because of that, it's right to come to the court. So the court is actually a very limited spot for those kinds, for that kind of interim relief, in Singapore at least.
And just coming to that point about notice to the other side, of course, we now know that the SIAC rules and the HKIC rules as well have an iteration or situation where you can go ex parte potentially, at least initially, before notice is given to the other side. So to try and tackle the problem of a situation where you have to go to the courts, Philip, to your example rightly, where you want to go ex parte, the arbitral institutions are trying to come up with them, or have come up with a mechanism to address that as well. And so maybe, Geoffrey, over to you. My question is, are we going too far down the line of everything going to emergency arbitrators and very little role for the injunction judge? Or should the default not be EA? Should it just go back to the days of, here are the options on the table, and you just pick for the situation that you're in?
I think that if you ask a litigation lawyer in an arbitration situation where you need emergency relief, who would you rather go to, the court or the arbitrator? I think most would say, I think anyway, go to the judge, because if it's suitably urgent, you're going to get an urgent, you can get an urgent appointment. And as far as the enforcement of that is concerned, if you get your injunction, for example, it's there. Whereas actually in terms of an emergency arbitrator, probably at some stage you're going to need the assistance of the court. Now that said, however, because of the provision for an emergency arbitrator in rules, say the SIAC rules or the HKIAC rules, and this is the way the courts look at it, and the way that the legislation is drafted, is that the courts would expect parties to go to the EA first, and only when certain conditions are met would you really have initial direct access to the courts. Now, this causes quite a practical difficulty, that the availability of EAs, actually, I don't know, I've never been an EA, but I don't know how available emergency arbitrators are in Singapore or indeed in Hong Kong, because if there's any slight difficulty with that, you just go straight to court. Because, to be quite honest, if I needed an arbitration right now, I could get an injunction right now because I just go to Philip next to me. And when I was a judge, I've had many occasions when people would visit me at night at home to get injunctions. Much as I dislike that, you just had to do that because, for a start, people don't take their shoes off when they come to your house. Nor would I, in all honesty, want them to. But joking aside, I think there are these practical difficulties. So the thing is, that is what we have, that's the world we live in. We have these rules, we have to make them work. Now, in terms of then making it work, then if you're going to have a serious system of an EA, you've got to have the rules in place, you've got to have the infrastructure in place. But I'm afraid I don't know how often there is recourse to an EA. I suspect not that often. I don't know the position in Singapore, though. Somebody else.
Well, we have
perhaps tell me.
Lucy's in the audience. You're probably able to tell us how many EAs were appointed last year, for example.
15.
1-5. Okay, that doesn't sound like a lot. Yeah.
15 a week or in court. No, a week in court.
Oh, yeah. You get a lot more in court. Yes.
And is it the case, if I were to say to you that all things being equal, for instance, there is availability of an EA, and of course some institutions actually do advanced checks, and I think a number of them have a panel where they have particular people who say they have experience being an EA and therefore eligible, they will set aside the time and they will give a decision as quickly as the party wants it. Is it just a procedure point, do you think? And is that the way to overcome that, just to ensure that there is availability to be able to discharge the function?
Oh, well, actually, my answer, I think this is actually a systemic question rather than an individual case question. And I think that it might be that arbitral institutions have gone a little far in thinking that the best answer to everything is give more of it to us. It may not actually be the best answer from the point of view of the overall system. But there may also be another point, which is, of course, arbitral institutions, or at least some arbitral institutions, will have will be involved in seats which are all over the world. And then you might well see that you might feel that it's better to have this option of an EA from your institution than going to a court in place X or Y. But that may not necessarily hold true for all seats.
Okay, let's go back to a point, Geoffrey, that you made earlier about finality. And I think, Philip, you also spoke of this point of how much of an advantage, or has it grown to be an advantage in arbitration? I want to put it as a question. Is finality really still an advantage of arbitration? It is only one shot, as you say, measured against, in some jurisdictions, there is more, I guess, evidence of using the avenue of public policy to scrutinize merits. By and large, finality is meant to be that. It's meant to be you can't interfere with the award. Now, of course, the proper exception to that is appeals on a point of law. And I want to focus on this because, of course, things are evolving as we speak. Hong Kong has had it as an opt-in mechanism. England has had it all along, and Singapore is now considering it. So perhaps to you, Geoffrey, first, do you think it's right that arbitral legislation should earn favor of allowing appeals on a point of law? And it's a generic question, but against your experience of, obviously both capacities, is it right to leave that remedy there available? Or do you think it's just more opportunity for parties to try and fit square pegs into round holes?
The answer is to be given under sort of with two aspects in mind, one the theoretical, the other the practical. On the theoretical basis, you can put up a strong case for both. Against the idea of finality is the theoretical view that if something really has gone wrong in an arbitration, now, if something really has gone wrong, is probably by definition a matter of law, even though it involves facts or procedure or whatever. It'll be regarded by courts as a matter of law. Then there should be some remedy, because otherwise it is unjust or it is unfair. Right. That's the one side, the theoretical side, against the idea of having one stop. The other side is this, which is that the whole idea of an arbitration is that it is one stop. When parties make an agreement to go to arbitration, actually before disputes arise, and at that point, both parties, what they want is to have a quick resolution without the prospect of going on appeals and so on. I know by the time you get to a dispute, the party that loses will say, well, actually, I wouldn't mind going on appeal. That always happens. Whereas the side which wins is going to say finality. So you've got it. This is a policy point which has been agonized over many, many years, over decades, if not over a century, about how final is it going to be. Of course, arbitration legislation started off by being not final at all. You just carry on. From a practical point of view, given again, the expense and everything, and the desire to get things over with, in a way for better or worse, parties would like to see it resolved without the need to sort of carry on. Although the practical side is the same as looking at it from the other point of view, the practical side is, well, surely the parties that have been hard done by as a matter of law should be able to go on appeal. I think at the end of the day, this is a policy matter. It is entirely a policy matter. And you've got to go one way or the other. To have exceptions is going to be very difficult to operate. Now, the compromise, which I think is a good compromise, is the opt-in procedure. You anticipate at the beginning, well, if something really goes wrong, we can opt into an appeal. To have the appeal procedure forced upon a party when both parties were happy to have one stop, I think needs careful thinking. And that, I rather suspect, I don't know, is what's behind the thinking in Singapore. It's considering these options, because I think here matters of principle do matter.
Right. So, as Geoffrey has said, it's very much a matter of policy where one goes. But I think in considering that policy, and I suppose the other thing to say is, obviously in Singapore, the potential reform is an opt-in appeal, not nothing more than that. I think one obviously then has to consider things from a system point of view. In particular, what are the timelines that one system or the other might create or effect? And I suppose the irony is that the one-stop shop idea may be thought to make things faster, but I think in practice hasn't, because you get everybody throwing in huge resources for this one-stop decision. I mean, again, I don't know what the figures are, but it certainly looks to me as if arbitrations are taking a lot longer than they used to do 10 years ago, say.
And this brings me to my last topic, actually, that last comment you made there, Philip, which is where we were 10 years ago, where we are now. I'd like you to look ahead 10 years, if you can, and crystal ball gaze for us a little bit. You know, we're sitting here in Asia. Singapore and Hong Kong in particular have made significant progress. We heard the story about how Maxwell literally physically made progress over the years under your chairmanship, Philip, but also, of course, Geoffrey, you'll agree with me that Hong Kong has just gone from strength to strength in terms of being one of the most popular Asian jurisdictions. And actually, both cities have made it to the global map and their respective institutions. And this is really saying something of the statistics that both choices of seat and also arbitral institutions, Asia occupies a good part of the top 5 global spots. So that's where we are today. It's a great place to be. We can be very proud of ourselves, but we can't be too complacent. So the question to ask is, where do you see us headed? I'm not just talking about Hong Kong and Singapore here. If you look around you at other jurisdictions, there's been so much change and development, reporting of statistics on enforcement, for instance, in places like mainland China, jurisdictions like Japan and Thailand revising their arbitration legislation, and of course, getting very strong pro-arbitration judgments from cities all around Asia. As a hub, do we think we can continue to just move in the direction that we're in? Or are there any words of wisdom / caution that you want to share with this room? I leave it to you as to who would like to speak first, for once.
The wiser person speaks first. Sure.
All right. Okay. Well, I think the short answer to your question, and if there were, I don't see many young Singapore lawyers in the room. I see lots of older Singapore lawyers in the room, but not the younger ones, maybe because they're busy doing the work, probably. But the message to them would certainly be that I think the future for Singapore law and for Singapore as a dispute resolution hub is just astonishingly bright, actually. Now, that comes with something else, which is that a key to the success of Singapore has been our openness. Openness to new ideas from elsewhere, our openness to actual people from elsewhere as well. And that's really, really important that continues. So Singapore, probably our one difficulty is we don't produce enough babies, and we don't have the critical mass of Singaporean talent. So that, among other reasons, is a good reason why Singapore should be open when it comes to professional services. And I think over the next 10 or 20 years, you will continue to see, and this is crystal ball gazing, but you will continue to see great growth in the dispute resolution space for Singapore as a place. And young Singapore lawyers will, along with a lot of others from all over the world, really benefit from that.
Contrary to what Philip thinks, I only see young people in this room. The fact that Asia is now very important as arbitral centers, not just Hong Kong and Singapore, but indeed elsewhere. In fact, there's going to be a session, or is a session going on in relation to Korean arbitrations and so on. There is no doubt that Asia will continue to be the powerhouse that it is fast becoming. It will be a major powerhouse to which everywhere else in the world will be looking to for the highest possible standards of dispute resolution by way of arbitration, mediation, and so on. And it is this likelihood, I don't think you need too much of a crystal ball to work that out, which should drive standards up, and not just the maintenance of standards. We've been talking in a way a lot this morning about how high standards ought to be for various reasons in order to attain justice and fairness and those ideals. Those are matters to be looked at, to be strengthened. You'll never get perfection. You never achieve that, but you keep on striving towards that. And that, I think, is the challenge for all those who practice in arbitration and dispute resolution within Asia, not to sort of regard themselves as an up-and-coming powerhouse, but an actual powerhouse which has the responsibility, the commensurate responsibility to do the best it can. That's how I see it.
Thank you so much for those words. I'm going to say that, and I'm mindful that we've run over slightly, but with permission, actually, for once on my part. Before I wrap up, I am going to look at the audience to see if anybody has any questions for our guests. Not for me, please. My job is just to ask them and not to answer them. But if there's anything else that anybody would like to ask, please do feel free. And otherwise, it remains for me to say that I'm so thankful for your time and for your candid views and for the discussion that we had this morning. At least on my part, and I know I speak for everyone in the room, there is so much to be gained from this type of discussion and so many learning points to take away as we practice day to day in whatever capacity we're in, whether that's counsel, in arbitration, litigation, or as decision makers, or as users otherwise. So thank you very much, both of you. And I'm very, very grateful to Maxwell Chambers as well for this event. Thank you for your time.